Hello, I'm Jeff Bast from Bast Amron.
I'm Brett Amron from Bast Amron, and this is the Practice Podcast. Today, we're going to talk about Chapter 11, but a specific issue in Chapter 11. You know, when a debtor or prospective debtor comes to us, we always talk about trying to avoid bankruptcy, but in the event that bankruptcy is unavoidable and is filed and is a Chapter 11, we always come up with or try to come up with an exit strategy before we put the clients in. And one of the big issues that's popping up today is always an issue, but there's some unique issues that are surround it, which is lease agreements and executory contracts relative to lease agreements on both sides with tenants and landlords as a result of the COVID-19 crisis. We want to talk to you about some of those issues that are popping up today and some of the things we're seeing out of courts, not just where we are, but across the country that have issued some orders relative to that.
Yeah, and it's actually it's not unique to Chapter 11. Obviously, the issues in Chapter 11 are operating issues, as Chapter 11 is reorganization and Chapter 7 is liquidation. These are issues that come up in almost all bankruptcies, and we're seeing it on both sides. Some cases we're representing the tenants, some cases we're representing the lessors, but lease issues, and these are not, we're talking primarily about commercial leases for real property, but this is an issue for any type of executory contract or lease. And an executory contract is really one where performance is outstanding on both sides of the agreement. So it could be a commercial lease, it could be a service agreement, it could be a lease of a piece of equipment. These issues come up in almost every bankruptcy case, but we're seeing it now, particularly where a lot of business locations are closed. These are hot topics. Lessors are not getting paid, tenants are not able to pay rent, lessors are not paying, and we're getting contacted by tenants and lessors in cases around the country, particularly in the retail space. We're seeing there's so many filings with multi-debtor locations that are impacted by COVID and the various state orders requiring shutdowns. So the issues are, there are a number of issues, but we could talk generally about executory contracts. A debtor in a bankruptcy case has this great power, the right to assume or reject contracts, executory contracts and leases. So they have that right to either keep the lease or get rid of it. And rejection is kind of a cleaner and easier topic. That if the lease is rejected, it essentially affects a breach as of the bankruptcy date, the petition date, and the lessor in that circumstance wants a couple of things. One is they want to get paid, so they want to maximize their claim and make sure that the rejection date is as of the latest date that they can secure, and that they can secure the premises, that they get the premises back, and that they get paid. So in some cases, we're seeing, and a lot of, we're seeing a varied approach across the country in a lot of the cases. In some, they're rejected right as the beginning of the bankruptcy. We saw one case recently for a client where almost all the leases were terminated pre-bankruptcy, at least those that they planned to reject, and they were handing over the keys. We had a client that didn't get the keys. They hadn't been given possession, so we were not fighting, but working to gain possession of the premises as early as possible. And now we're trying to maximize their claim in the case so they can hopefully recover some of the money. But even the claims in a bankruptcy as a result of a rejected lease are capped at generally 1 year or 15% of the balance of the lease, with a limit of 3 years, but it's usually around 1 year.
And just to jump in for a second,
Yeah, go ahead.
Yeah, so I know there's tenants, sometimes take advantage of the time allotted to them. I know, with executory contracts to assume or reject, with real property, there's a smaller window within which they have to assume or reject. Landlords want to push that. What have you seen, if anything, in terms of some, judges requiring them to move faster, or giving them more time, giving tenants a little more time to determine whether
Right.
or not they can assume or reject?
Well, generally, in Chapter 11, there's a general proposition that a debtor has to maintain its obligations during the Chapter 11. So while you're operating, again, in Chapter 11, a debtor continues to operate. While they're operating, they have to meet their obligations post-bankruptcy. But ordinarily, they're given great latitude in doing that. They have to pay the expenses during the bankruptcy are called administrative expenses. They have to pay all of those by the time they get to confirmation. The commercial landlord, organizations had a good lobby, and they negotiated favorable treatment in the bankruptcy code, and it requires a debtor to pay during the case their lease obligations, but the code has given the debtors 60 days. So there's a 60-day breathing room before any of those obligations start coming due. The debtors have 60 days, and then after the 60 days, they're required to pay. But the effective non-payment essentially is a claim, which has to be paid by confirmation. So there's always a timing issue. And what we're seeing now, actually, in a bunch of cases, is even that 60-day window is becoming expanded. In fact, there's quite a few retail cases in which the courts have entered what many are calling mothball orders. And in the mothball, they're basically suspending the whole case and all of the obligations. So nobody's getting paid, and those time periods have expanded way beyond the 60 days. So we are in unprecedented times, and we're seeing unprecedented, movement in Chapter 11 cases.
So that's favorable. Obviously, those mothball orders are favorable to, meaning, like you said, the case is stayed relative to the executory contracts. There's no, the debtor doesn't have to assume or reject. The debtor doesn't have to pay anything. And so if I'm a landlord, right, as you said, we do both sides. If I'm a landlord, what do? I have obligations, right? If I have, if I have obligations to my lenders, if I, have to make payments to vendors to keep the lights on for other clients, if I own a shopping center or a mall, what's a landlord to do at that point? What can a landlord?
It's a tough, it's a tough issue. You hit, Brett. That's exactly what the lessors are saying in cases around the country. What about us? We have mortgages. We have some of them have their own landlords, because some of these are, there's a ground lease, and so
Right.
In many of these cases, that's what the landlords are saying. And so the courts are struggling with finding that balance between protecting the lessors and protecting the tenants. And really, this notion in Chapter 11 that society's better off with this business surviving on some level. So for lessors, they want to, obviously, if in many respects, it's too late to try to do this now, but you want to have as much security as you can, in terms of a security deposit, maybe a letter of credit, corporate guarantees or personal guarantees from non-debtor entities. Obviously, they want to keep tenants as current as they can in advance of a bankruptcy. And so if they have wind of some filing, they want to try to collect payments as much as they can pre-bankruptcy. Got to retain counsel early on, because in a lot of these cases, things are moving very quickly, and orders are entered in the early days of the case. And by the time some creditors lawyer up, a lot of the protections have already been diminished. And so it's important to be involved early on so you can protect and preserve your rights. But courts are, the bankruptcy courts are gaining flexibility, and they recognize that we are in these unusual times, and it's a struggle.
Yeah, and I wonder if, look, I think some of these mothball orders came, I don't want to say at the beginning of the pandemic, but early on, or earlier in time.
Yeah, for sure.
And I think some of the judges probably said, you know what, let's take a pause. I'm guessing, of course, but that some of the judges took and said, you know what, let's pause and see what happens here, but nobody, I think, anticipated that this was going to continue on in the fashion it has for as long as it has. And so as it continues, I think judges are going to have some really hard decisions to make relative to, you know, balancing between, you know, trying to
Right.
get this debtor through a Chapter 11, and the landlord's obligations and rights too,
Right.
because, you know, you can't have a mothball order in place forever, you know?
Right. Yeah. I mean, you're right. A couple of those cases even um, filed even before the COVID crisis really occurred. And so, in one or two of the cases, there was a sort of a liquidation plan, not a plan of liquidation, but a plan to liquidate some of the stores. They were shutting down some of the locations, or in some instances, all of them. And then the shutdowns happen, and so you can't really have a going out of business sale, if you will, when stores are closed. And so, and what happened is, in many of them, most of the creditors, either the committee of unsecured creditors or the secured lenders, supported the mothball. And so, remember, I think what a lot of people lose is that bankruptcy courts, that's why what our practice is so unique, is that bankruptcy court's a court of equity. And so the bankruptcy court has to find this balance between what's in the best interest of all creditors, even though some creditors are obviously going to be harmed by those actions, what's in the best interest of the estate and all creditors. And that's a struggle. But I think in many instances, what we look at is this creditor worse off as a result of the action of the court? And so oftentimes you'll see for a lessor, maybe the most compelling thing they could argue is that, hey, I have another prospective tenant for this location, and you're precluding me from doing anything. I can't evict this tenant. I can't do anything. The debtor that's in bankruptcy. And so here in this crisis, no landlord can really come in, or I'm not aware of any, can really come in and say, I have another tenant for this space. It's a restaurant or it's a retailer. There's not a lot of restaurants knocking down the doors. And so I think a lot of courts are looking at this from, what's the alternative? Am I really causing harm to this lessor by precluding them? Because really the big, besides the mothball, but the major stumbling block to a lessor is the automatic stay. The automatic stay in bankruptcy is precluding them from taking their normal actions that they would take. And so I can't collect rent, and I can't evict them. I'm stuck. But the bankruptcy court's saying, well, what would you do otherwise? And the other piece that you and I haven't touched on yet, which is coming up in almost all these cases as well, not just bankruptcy cases, is the challenge to the obligation to even pay rent. A lot of lessors are looking to those provisions of their lease, the force majeure clauses, or impossibility, or frustration of purpose, or takings, and saying, hey, I've been shut down by the government. I cannot operate. The purpose of this lease is frustrated. And the lease, and depending on the applicable state law and the terms of the lease, they may not have an obligation to pay rent.
Well, and further to that point, which is that there's a lot of, stays on evictions right now, right? Depending upon where the jurisdiction, where the business is, and where the action can be asserted. There's a lot of moratoriums on stays, on evictions right now. And so, I think the pitch for a tenant, the pitch to a bankruptcy court is, judge, they couldn't even get if you're in that jurisdiction and it falls within that fact, judge, they can't even go get an eviction right now. So let's stay it or mothball it. And that's putting landlords obviously in a difficult bind, with their, again, with
it's a tough issue.
Yeah, it's a tough issue that I think my guess is will start to evolve, and things will start to happen, instead of mothballing as, each week and month continue. I think it's going to be harder and harder to just continue a mothball, unless there's other things happening behind the scenes that give the bankruptcy court the confidence that perhaps this business will be able to come out and thrive. And I think, like we talked about, which is, e-commerce, to the extent that there are some retailers that are able to, generate some revenue through e-commerce, and not, and perhaps if their brick and mortar locations are, closed
Yeah.
or only operating at a reduced capacity, if they can pick up some revenue that way, maybe there's some light at the end of it.
Yeah, I mean, I think e-commerce is keeping a fair amount of businesses alive, but it's just not enough. There's no way they can make up, and it's kind of like restaurants. A lot of them are doing takeout and delivery, right, but it just doesn't make up for the in-store service. And I think you and I, or the conversation we're talking about with the mothballers, mostly comes up in large national retail chains,
right?
Modell's, Pier 1, Kraftwerk. We're seeing it all over the place. But this doesn't really touch on the small business, the small mom and pop restaurants who really don't have that luxury and are going to have a much more a difficult time. And many of them are not going to survive. But the important thing for them to realize is that there are some protections, and that bankruptcy does provide some breathing room. What it doesn't do is it doesn't allow you to force a modification. So you can't, if you want to file a bankruptcy and negotiate with your lessor, you can do that. But the bankruptcy court cannot force the lessor to modify the lease on a long-term basis. And if a tenant in bankruptcy wants to keep that lease, they have to assume it. In order to assume it, they're ultimately going to have to cure whatever defaults there were. Now, whether or not those defaults require the payment of rent based on what we talked about, impossibility and frustration of purpose and force majeure, that remains. That's going to be a function of the terms of the lease and the applicable state law. But these are challenging issues and challenging times, and we're going to have to. We're taking it step by step. But the important thing for either a tenant or a lessor is get in contact with a knowledgeable restructuring attorney who can guide you through this process, and do it early.
Yeah, agreed. And I think you raised a good point, which is a lot of what we were talking about with the mothball is, businesses across the country, and the basis for the fact that, hey, we're trying to bring back jobs across the country in a lot of locations. Small businesses that have one or a couple of locations don't really have that benefit or that argument. And so it makes it a lot more difficult for them. And so proper planning, proper advice and consultation with a professional to hopefully try and save the business, and try to negotiate with landlord and creditors, really is the best way to do it.
We've mentioned the SBRA, the subchapter 5, which is the new small business provisions. And I think that's going to be, will continue to be a useful tool. And the thing with chapter 11 is it's a system of consensus. So in most chapter 11 cases, we tend to work things out. And so it provides a real nice vehicle for negotiation among parties, lessors and tenants. And so I expect that, we're going to continue to see more and more filings, and hopefully we can save some small and mid-sized businesses as well, not just the big national retailers.
Agreed. All right. Thanks, everybody.
Well, thanks.